our speakers today, and I will begin with Lori Wallach. So Lori Wallach is the director of the Rethink Trade program at American Economic Liberties Project. She is also senior advisor to the Citizens Trade Campaign, the U.S. National Trade Justice Coalition of Unions, and Environmental, Consumer Faith, Family Farm, and other groups. Wallach, a 30-year veteran of international and U.S. congressional trade battles, starting with the 1990s fight over the North American Free Trade Agreement and WTO, has encyclopedic knowledge of trade pacts, policies, outcomes, and politics. She was named to Political's 50th list of thinkers, doers, and visionaries transforming American politics for her leadership in the Trans-Pacific Partnership debates. She is an international recognized expert on trade with experience advocating in Congress and foreign parliaments, trade negotiations, courts, government agencies, the media, and in the streets. Dubbed the trade debates guerrilla warrior in a National Journal profile and Ralph Nader with a sense of humor, in a Wall Street Journal profile, Wallach combines a lawyer's expertise on the terms and outcomes of agreements with insights from the front lines of trade debates. Wallach's specialty is translating arcane trade issues into accessible language. A lawyer who has worked in television news and on political campaigns, Wallach has testified on the TPP, WTO, China trade, North American Free Trade Agreement, Fast Track, and other globalization issues before 30 congressional committees and appeared as a trade commentator on Fox, CNN, ABC, Bloomberg, and numerous foreign outlets. She has published and quoted in the New York Times, Wall Street Journal, the Washington Post, Financial Times, Foreign Policy, The Economist, Forbes, USA Today, and more. She is currently focused on the dangerous big tech digital trade ploy to lock in their monopoly powers and evade regulation, supply chain disasters caused by decades of hyper-globalization and corporate concentration, and the trade pact enforced monopolies limiting the supply of vaccine needed to end the pandemic. Wallach was also a founder of the Citizens Trade Campaign, the U.S. National Coalition, representing more than 11 million Americans and serves on its board. Wallach is a native of Wisconsin, graduated from Wellesley College and Harvard Law School, and now spends much of her time in Washington, D.C. Our second speaker is Daniel Rangel. Daniel Rangel is the research director of the Rethink Trade program at the American Economic Liberties Project. Daniel has a decade of experience working on trade and investment law and policy and has authored major reports on digital trade, WTO law, labor aspects of trade agreements, and the distributional outcomes of trade. With that said, I will now hand it over to our speakers to begin their lecture. Over to you, Lori and Daniel.
Hello, everybody. Depending on where you are in the world, good afternoon, evening, morning. I am very honored, as is Daniel, to be invited today. And Megan, thank you for that introduction, which is reminding me I need to shorten that bio. Sorry, everybody, for all of those details. And Joanna, thank you, and Megan for moderating us today. How Daniel and I thought we would do this presentation is I would start with some overview of what these rules are and what we learned in the context of the US debate, which has been fairly heated over the last 2 years and has shifted. As Joanna said, the position has shifted to a more public interest oriented one. And I wanted to share a little bit from our experience here, thinking perhaps understanding that history might be relevant to the work any of you might be thinking about doing with the African Continental Free Trade Agreement. So I'm going to share my screen and bring up some slides, and I will do a little overview. Then we will proceed to Daniel, who will, he has done some analysis of the digital trade protocol of the FCFTU and AfCFTA, and he will go into a little bit of detail of what he saw in the text, and then we can go into the discussion. So with that, I am going to share my screen and get the slides to come up, hopefully. And Megan, can you nod if you can see the slides? Wonderful. All right, thank you very much. So the place I wanted to start, and given many of you are law students, this is not going to be a surprise or really new information, but the way that the digital trade strategy being employed by the largely US big tech companies works is using the function of the WTO and other trade agreements. That is the requirement that countries conform their domestic laws to the rules. So the brand that is being used is digital trade, but the actual function is to use what many civilians, non-lawyers, do not realize is the obligation. We all know that every trade agreement has something like what is in the WTO that requires each member shall ensure conformity of its laws, regulations, and administrative procedures, which is obligations that are provided in the annexed agreements. Every trade agreement has some kind of an obligation that requires that you have to meet the rules with respect to your domestic or regional laws. And the enforcement mechanisms that are in trade agreements make trade agreements one of the only forms of enforceable international law. There are ILO, International Labor Organization rules, there are multilateral environmental agreements, but those instruments typically don't have sanctions involved that actually have a hammer coming down if you don't conform your laws domestically. So with that as sort of the context, and I put in the Trojan horse because it's not a Trojan horse. Lawyers, trade lawyers particularly, know it's not a Trojan horse, but for the public, and I will offer that we found with the US Congress and policymakers outside of the trade agency, they saw this as a Trojan horse situation, in that many people still think of trade agreements as focusing on the traditional stuff, tariffs, quotas, market access. And so the notion that there would be rules that would have implications for domestic policy space with respect to something like regulating for privacy and regulating tech platforms was news and was described as a Trojan horse to us by some of the people with whom we discussed the findings. So we started thinking about this because the big tech firms seemed to be trying to use a strategy that the big pharma firms had used in the past. And that is, many of you are familiar with the pharmaceutical lobby seizing on the negotiations that established the WTO to implement extended patent monopolies, so classic rent-seeking monopolies in a free trade agreement, and they use that obligation to conform your laws to make the whole world try and have the kinds of rent-seeking, very strict extended patent obligations, which, as we saw worldwide over and over, has limited affordable access to medicines and has nothing to do with free trade. So starting with the Trans-Pacific Partnership, which was a 12-country negotiation that the US started during the Obama administration, the US big tech lobbyists tried to start pushing limits on regulation of the digital sphere. And what they did is past US agreements since an agreement in 2004 with Singapore have had e-commerce provisions that had to do with the digitalization of actual trade in goods and services. So what is a legitimate online contract? That is an actual good question for a trade agreement, but it didn't have rules limiting, for instance, what countries could do with their domestic privacy law, et cetera. So the industry fabricates this brand, digital trade. It's not e-commerce, it's something beyond that. And as well as the United States, Singapore, I would say, was the big leader with strong support from Japan and Australia and some other countries. And these countries start pushing this agenda with the big tech lobbyists very much informing it in numerous venues. They try to get a global WTO digital trade agreement, numerous regional negotiations. Singapore does a lot of negotiations that bilateral free trade agreements, others that have these regulatory constraint frames. And In the US, the Trump administration gets these rules actually into the renegotiation of the North America Free Trade Agreement, which Trump called the US-Mexico-Canada Agreement, or sometimes called the USMCA. The USMCA is the only, even though the US was seen as behind in pushing these rules, the USMCA is the only agreement Congress approved that has these kinds of regulatory constraints. And as someone who was there during that fight, many people in Congress and I did not realize the extent of the potential threats these rules pose. Many in Congress didn't even realize these rules were in the agreement because many of them took the opposite position of what these rules would require. In 2019, right around when that USMCA passed, the Trump administration then submitted the 5 particularly pernicious rules as a US position at a WTO proximate agreement negotiation, called the Joint Statement Initiative on E-Commerce. This is sort of a rump negotiation, and I can recommend an excellent paper from a University of Auckland law professor, Jane Kelsey, about why rump. It was never actually started using the WTO rules that require consensus of the signatory countries. So a variety of countries, 90 of them, a subset of the WTO members, started doing a negotiation on the side. And that is often called the JSI or JSI e-commerce. That negotiation, the Trump administration submitted these rather outlandish USMCA provisions as the US proposal. Interestingly, our past agreements didn't have those rules. I'm going to explain what they are, and you'll see perhaps why they didn't. And most other countries' agreements don't. There are almost 200 trade agreements that are covering e-commerce, or the more current ones are called digital trade. And these particular provisions I'm going to outline that Daniel and I have identified as the most threatening to domestic policy space with respect to really non-trade regulatory concerns like competition policy, antitrust, AI regulation. Those particular rules are not in most other countries' agreements either, which is why, as Joanna mentioned, it is unusual and interesting that they popped up in the draft of the African Continental Free Trade Agreement. So the big news here in the United States is, after some period of time, because just for full disclosure, the Obama administration also was working during the TPP negotiations with the big tech guys for some of the same rules. The USMCA ones are more extreme, but the TPP version is plenty bad. And the US never joined the TPP. There was never a majority in Congress in 2015 and 2016 to actually enter the agreement. So the US never joined TPP, but those rules were sitting there as the US proposal in WTO. And in 2023, the Biden administration formally withdrew US support for 3 of those particular rules. They altogether withdrew a 4th one. And quietly in 2022, they had already withdrawn 1 of those rules. This has made big tech furious. There's a big pushback. And if you want to hear the ugly moment of current fight, I can share it. But the big news is it doesn't look like the big tech guys are going to win this one. And Daniel and I will describe a little bit of what we use as a strategy here, which may or may not be relevant there. But the short version of it is we just made sure that the members of the Congress and the regulators in other non-trade parts of the government were aware of what could happen with the things they were working on AI oversight, on right to repair policies, on privacy and competition policy, if these rules went into place. And then they began to discipline the trade agencies in the process. So the set of rules that are the ones that are to look out for, that are the ones that the administration, the Biden administration, most recently in October 2023, withdrew from support at the WTO proximate JSI, are unlimited control of data. And basically, flows of data cannot be regulated, including for some very good reasons, because the exception that's in this provision, which I'll explore with you briefly online, does not function. And we've listed throughout in our papers, et cetera, which actual provisions these are. So you can go back and we can, of course, we'll share the slides. New secrecy guarantees for algorithms and source code beyond, the trade secrets rules that already apply through the WTO. And these were designed to keep these instruments from being reviewable. And then designation of many anti-monopoly policies, neutral domestic laws as potential violations of a principle of non-discrimination, which we all know is very common in trade, but it's turned in its ear in this instance, where basically even facially neutral non-discriminatory policies can be seen as discriminatory if they have a discriminatory effect. Now, of course, almost every competition policy targets the dominant companies. And if they all happen to be US and Chinese, that is not because the countries regulating for anti-monopoly are out to stick it to the US and the Chinese, but rather because those are the companies you want to break up if you're trying to deal with monopolies. But under that rule, that kind of law, which is totally legitimate, could be labeled an illegal trade barrier. I flagged this report because this was perhaps the turning point intellectual instrument in the US debate, which is Senator Elizabeth Warren, a great progressive senator who's very interested in these tech issues. Her team asked us, could we look at the US specific laws being proposed or regulations being proposed that could be affected? And so a lot of this report, we literally just have side by side. Here is the law. Here is the provision that could nail it. Here's the particular part of the law. Here is the actual proposed digital trade provision that would undermine this policy being proposed in a bipartisan basis in Congress. And it just proved to be a majorly useful tactic, because whether or not you agreed with our view of what you should do to regulate big tech, the most conservative Republican who might support a piece of privacy legislation can look at the language and say, wait a minute, I'm the parliamentarian. Why is this being undone in a trade agreement? And then form their own view. This slide basically goes the other way around. Instead of talking about the legal provision, which I put first because we're lawyers, it talks about the issues. And this is another thing that we learned the hard way in the US debate, which was the importance of making sure that people who are not lawyers can understand. So we did a lot of educating based on, here's what's at risk that you, as a legislator, as a regulator, or as a person in a consumer group, human rights group, care about. So online privacy, data security, so where the data can flow, is it safe? Data disgorgement as an anti-monopoly remedy, and that is the government's being limited from regulating data flows. AI regulation, the prevention of online discrimination, bossware violations, the software that tracks workers, the right to repair, gig worker labor laws. These are civil rights online. These are the kinds of laws that could get clobbered by the secrecy rules for source code and algorithms, because you can't review and make sure that there aren't problems embedded, or you can't require for right to repair the right to have a digital code or an update of software. Competition policy and general laws of applications that affect bigger firms more, as I explained. The so-called anti-discrimination rules would clobber that. And then down there in faded ink is the fifth rule that already had quietly been clobbered and taken out in 2022. The USMCA actually extends a very controversial law in the US called Section 230, and that is a broad liability waiver for platforms. And on a bipartisan basis, there's interest in reforming that. So that was the first one that got taken out. So just to review the different rules, I pulled up the language of the actual provisions. This is the provision on not allowing regulation of data flows. No party shall require a covered person to use or locate a computing facility in that party's territory as a condition for conducting business. No party shall prohibit or restrict the cross-border transfer of information, including personal information, by electronic means, if this activity is for the conduct of the business of a covered person. Now note, that's not saying you can't restrict data between the parties, because you may decide between certain countries, you're happy to have the data flow. You might have an agreement, you trust their privacy rules. Frankly, I would rather have my data in Europe than in the US. I would rather have it in Kenya. Many countries have better privacy rules than the United States. We don't have a federal privacy rule. It's a scandal. But this rule says, no, it's not just between the countries. This data has to go anywhere that businesses and the business of a covered person is defined as an investor or a service provider. So anyone a business operating where they want to send the data, they have the right to send the data. And then here's the exception. This article does not prevent a party from adopting or maintaining a measure inconsistent with paragraph 1 that is necessary. All ye trade lawyers know that's a word with complications, to achieve a legitimate public policy objective, provided, warning, here comes all of the chapeau of Article 20 of the GATT, the general exceptions, that is not applied in a manner which would constitute a means of arbitrary or unjustifiable discrimination. Okay, that's a reasonable thing. Or a disguised restriction on trade. What the hell does that mean? Some WTO tribunals have been very creative in deciding what that means, and does not impose restrictions on transfer of information greater than necessary to achieve the objective. So proportionality test. Now, the reason why that's all in yellow is because the GATT Article 20 exceptions, which are the general exceptions, and that language that is the chapeau of Article 20, every country that has tried to use that since WTO was established in 48 instances has failed, except for 2 instances. And for wonks of Article 20 of GATT, the 2 instances were the ones that were the natural resources in relation to uses, not the necessary to uses. And Daniel Rangel, my colleague who you're about to hear from, is the guy who wrote the law review article about this that went through painstakingly all 48 cases and has it charted out to show where on the chapeau and or the necessary test these cases fail. So the bottom line, though, is as lawyers is, for God's sakes, if you want to have an exception that works, don't use that one. And moreover, since basically the middle 2000s, the United States doesn't use that exception in its free trade agreements anymore. We now have language for the exceptions that we're serious about, like national security, that have an element of self-judging and get rid of the necessary. So this is just FYI to give some comparison for the US, not so important for many folks thinking about this in an African context, but the industry demand is exactly that extreme language. And then these are the US laws that would be the US bills, proposals that would be clobbered. More important is the amber colored boxes, which just give the overall ideas of what kinds of limits would be imposed with respect to privacy, with respect to data security, with respect to access to data for research, etc. So, and some of these rules are civil liberties rules, some of them are privacy rules. The next provision is the secrecy one. So this is the USMCA article, and the rule is, whoops, I don't know why it just did that. Sorry, it just changed itself. No party shall require the transfer of or access to a source code of software owned by a person of another party or to an algorithm expressed in that source code as a condition for, and it's all the ways you could use the software in its territory. And then again, an exception with a trap. This article does not preclude a regulatory body or judicial authority of a party from requiring a person of another party to preserve and make available the source code of software or the algorithm to the regulatory body for a specific investigation, inspection, examination, judicial proceeding, enforcement action, etc. Now, the complication here is that number one, the definition of what is an algorithm is just the defined description of the defined sequence of the steps. So basically all the kinds of AI oversight bills about civil liberties that require that there be a description, an algorithmic assessment provided to the government, that definition of algorithm covers that. And that is very broad. Ostensibly, this rule is about trying to keep this kind of source code from economic competitors. But the thing is, the TRIPS agreement at the WTO already has trade secrets rules. So that kind of unfair use, basically a government regulator gives to another competitor your special secret sauce, is already forbidden under the rules. If you ban the government from being able to do reviews, and particularly specific in the exception is very dangerous, because that is really limiting the reviews. First of all, it's limiting who can do the reviews or require the reviews. So a lot of pieces of legislation in the US would have Congress ordering pre-screenings, not specific, not we suspect there's something wrong with your online banking system or educational credit system or whatever it is racially prejudicial. We want to see your source code. You want to screen before the damage happens. And certainly with AI, you want to be able to screen in sensitive areas with respect to what damage could be done if it's let into the wild without being tested. So number one, you don't really need this. Article 39 of the WTO already has trade secrets protections. But number two, it's so broad that you can think of 1,000 ways AI will be used that you might want a government to have oversight of, even a description of an algorithm, and that would be forbidden. This would be an enormous escape from regulation boon for the tech companies. And just to give an overview, these are the different kinds of uses, right to repair policies, where a government might order a digital key or might order that a schematic or an update of software is made public. So your old phone, or you can go to an independent repair shop and get your car fixed. You don't have to go to the dealer where they can charge you an arm and a leg, or AI oversight, or any number of laws relating to law enforcement. Are you being discriminated against? Are you being sent to jail because people who have this color hair and are very short like me in the past have broken their bail and should go to jail first? Those are the kind of things that you don't want to have untested. So those are the laws, and these are some of the particular types of activities. Basically, proactive external monitoring is what the AI oversight is called, and that rule would shut it down. The tech guys want it to evade regulation. They don't want the oversight. And then the final rule, before I turn it over to Daniel, is non-discrimination. And all of you trade lawyers and budding trade lawyers, here is the trick, basically. There are different ways you can do non-discrimination rules. The US-Korea Free Trade Agreement had the old style, which bifurcated the standard so that if you discriminated intentionally, that's forbidden. And if alternatively, you have a neutral law, but that otherwise has discriminatory effect, then under that old rule, the tribunal judging if your law was okay was supposed to look at intent. Did you intend to discriminate? You had to find some level of intention. Now, unfortunately, there have been some WTO rulings since that bifurcated standard, which is a technical term. It differentiated between de facto discrimination, forbidden, versus de jure, which is you could have a neutral law. Oh, I don't know, the EU's #1 law on antitrust online, for instance, the Digital Markets Act, that targets the big guys, the dominant companies. The impact of that is all the companies that are targeted are US except for one Chinese company. So is that, again, trying to stick it to the Americans and the Chinese, or is that because those are the dominant players? If it's a neutral law based on dominance, you want to be able to do that. That's exactly what you do in a competition policy law. The USMCA rule conflates both of those tests, and it just says it doesn't matter if you intended it or not. If it has that impact, it's illegal trade discrimination, which would gut basically all of anti-monopoly law, antitrust law. The problem with those WTO rulings is such that now the Korea standard doesn't really fix it like it was intended to. And so if there's going to be a discrimination standard in trade agreements, the fix now is going to have to be to make clear the intent has to be proved and to make clear who has the burden of proving that intent. Again, just to show some of the kinds of laws, and here, the US industry has used this concept to attack a lot of laws already. So there's a South Korean App Store law that members of Congress are trying to enact here in the US, and that may happen this Congress. It's called in the US Open Apps Market Act. That South Korean law is in effect. There was an attempt to claim the US-Korea agreement forbid it. Thank goodness Korea stood to its position and didn't cave in, because That's a very important law that basically keeps the app stores of Apple and Google from not monopolizing. The Canadian Online News Act, an Australian one, that just basically means that the big platforms like Facebook and Google have to give negotiations for compensation for using all the news content generated because they get all the advertising. There's a US law that's trying to do that. As I mentioned, the EU's Digital Markets Act, the EU's Digital Services Act, and Germany's Digitalization Act. These are all laws that US companies have actually officially attacked. And if you go to our website, which is rethinktrade.org, we have a paper where we basically pull the US companies attacking on the record these laws to show this is not a hypothetical threat. So the companies have been trying to use these rules. They're not largely in effect. They are in a bunch of Singapore agreements. They are in the USMCA, but the companies keep making these claims even if they're not in the law yet. We've worked very hard to keep them out of US agreements, but there was a DG Trade, the European negotiating body, negotiated an agreement with the UK. They didn't stick basically thoughtfully to what their own laws were. And so as a result, the EU's AI law ended up getting rolled back. And the reason we know this is because a law professor in the EU, through a Freedom of Information Act request, basically found the information of DG Trade telling the regulatory agency, hey, you can't do this, not with our trade obligations. And of course, all of you studying trade law know this is just the US, the big behemoth who breaks all the rules in the world, actually changed its domestic laws when the WTO told it to, which gives some sense of the potential threat and power. I flagged this story, how big tech lobbyists took over Washington, because it links to this amazing research paper by a professor named Wendy Lee, Regulatory Capture's Third Face of Power. If you ever want a scary background read of the digital trade world, she was a young person answering phones at the US Trade Representative's office before she got her PhD. And that way she made friends with all the tech lobbyists. And they told her everything. And she took lots of notes and then interviewed them as a PhD candidate. And she has quotes that are very telling and very important. So just to conclude, why is the industry using trade agreements? Closed door, they can do things you wouldn't get away with in Parliament. The changes are impossible once the agreement's signed unless every party agrees. It's binding, it's enforceable. And then, the US big tech lobbyists are strategic. They want a global low road handcuffs on regulation agenda that applies for the whole world. And as compared to lobbying agreement by agreement, they hope to do regional agreements. They hope to lock these rules into the WTO, and then they can basically handcuff regulators and legislators worldwide from taking the actions that countries around the world are starting to take. And it's a little bit of a race against time, where they're trying to basically pour the cement around our ankles with these particular digital trade rules and hope that we get locked in so we can't do the things that, again, Kenya has a privacy rule, EU privacy rule, a lot of other countries. The US has tried to do that. A lot of countries are doing antitrust. Now there's a whole push for AI oversight. So with that, I will simply say that having the US backed off of the bad position creates more policy space for everyone else in the world. And what the next US approach will be is being fought out. But the trade representative just last week gave another speech talking about how she is going to make sure that US trade law, this is Kathure Tai, is the US Trade Representative, Ambassador Kathure Tai, she's going to make sure US trade law is consistent with the Biden administration's commitment to online privacy, to competition policy and breaking up the big tech companies, to AI oversight. And so there is a window here where the US is normally the 800-pound gorilla smashing up and down in everyone's heads to do the wrong thing and behaving badly in negotiations. And right now, the US has actually done the right thing at the WTO and has not pushed these rules in its specific negotiations. And with that, and we have a heavy fight going on to make sure it stays that way. There are a lot of very important members of Congress who are helping us. But with that, I want to pass the baton, please, to my colleague, Danielle Rangel, who has done an enormous amount of really impressive research on these issues, but also he was a trade lawyer in Colombia before he came to the US and got his LLM at Georgetown. And he has been looking at the trade agreement rules on digital trade of countries, of agreements from countries around the world. So please, Danielle.
Thank you, Lori, and thank you all for being here and for the invitation to have this morning for us to discuss these interesting topics. I'm gonna share my screen as well to show you some slides in which basically we took the knowledge that we have been developing over the discussions that we have been having at the US, in the US about digital trade, and analyzed the leaked text that came out in February of the AfCFTA digital trade protocol. It was very surprising to us seeing that many of the provisions that we have been discussing so heatedly in the US are very similar to the provisions that have been included in the digital trade protocol. We understand that the text that was adopted is very similar to the leaked text, although it's not public. But what we have been hearing is that basically it is the same text. So the analysis that I'll be presenting you is based on that February leaked text. But if something changes, no one can hang me for that because the actual adopted text is not public. So to start with scope questions. This is the scope of application of the protocol. As you can see, it basically excludes government procurement and what I will roughly call government information. When a private company is handling information for the government, that kind of information will be excluded from the scope of this protocol. But there are no other exceptions. So if you think about financial regulation, taxation, privacy frameworks, all of those will be covered by this protocol when it is actually ratified by all of the AfCFTA countries. So it could have a lot of implications. Now going specifically into the provisions that Lori discussed, this is the non-discrimination for digital products rule. It has a different structure than the one that we saw in USMCA, but in the end, what is very important here is that we don't see that so as to afford protection with the intent of protecting. We don't see anything that requires an eventual adjudicator, a panel under the AfCFTA that will be required to assess whether a measure is illegal or is discriminatory. Nothing is actually requiring an adjudicator to see whether a regulator or the policymakers wanted to discriminate against digital products from other countries or not. And that's very important because, as Lori mentioned, in the world in which we're seeing a lot of different rules that are targeting specific players, not because necessarily they're based in a country, but because of their dominance of the market, then it's easy to fabricate nationality discrimination claims. And just to give you an example, and this is something that is relevant all over the world, there's a big discussion about how we're going to make sure that journalists get their fair share of the content that is being circulated online all of the time. And at the vanguard of that discussion are Australia and Canada that have already passed some laws that require companies like Facebook and Google to negotiate with the publishers and give them a fair share of the revenue that they get from online ads. And those specific proposals have already been targeted as discriminatory by tech lobbyists. And what we fear is that this could happen in any other context. And it could happen, for instance, in Africa, considering that the AfCFTA has these very similar digital non-discrimination rules. So if South Africa, for instance, where this discussion is happening right now, were to adopt a law that is very similar to the one adopted in Australia or Canada, well, then this rule could be a tool for to challenge such policy. Going into data transfers, and these are the two articles that regulate data transfer in the AfCFTA. As you can see, the structure is very similar to what we found in USMCA. The states parties shall, and I'm going to go to the annex in a moment, allow cross-border transfer of data, including personal data, by electronic means, provided that the activities for the conduct of digital trade by a person of a state party. And then Article 22 is the ban on data localization measures. Here, what we're seeing, and this is something that we're being very critical about the USMCA model, is that it grants rights to private actors. As long as there is a person that is incorporated in a state party, so let's say Google is incorporated in Kenya, they can claim their right to move data across borders, and this doesn't have to be necessarily within Africa. This could be taking African data into other parts of the world, which is why we think that this particular model is very problematic. As I said, the obligation covers personal data, and something that is interesting about this rule is that it is conditions to the performance of digital trade activities. That's not something that is in the USMCA model or in other types of data transfers obligations, but it will be interesting to see how that is interpreted eventually. And the second thing that is very important about this is what Lori mentions. Here we see the same kind of exception that we found in the USMCA, which basically gives policy space, but it takes it back by including all of these requirements for a measure to be necessary or no greater than required. Basically, that's a proportionality test in which you're placing the right of private companies for data to flow over other public policy objectives, such as protecting people's privacy, and also this idea that the measure cannot be a disguised restriction on trade, which is very vague, and it could be used to claim that different elements of a policy don't conform with that and are disguised restriction on digital trade, and then the policy could be considered inconsistent. So something that is very interesting about this protocol is that it has all of these annexes, no? And I believe that the ones of you that have already studied the protocol have noticed that there's a lot of room to change the actual scope of the rules through these annexes. So here, particularly on the data issue, we see that Article 20.1 has this subject to an annex on cross-border data transfers. That, in my mind, means that the African countries have still not made up their mind, or the negotiators, on how much they're going to commit in this idea of unfettered free flow of data. And they are giving themselves some room to limit that commitment in a specific situations. Now, what's also interesting is that if you see the location of computing facilities provision, that one doesn't say explicitly that is subject to the annex on cross-border data transfer. So maybe that rule is already locked in and is not possible to change it with the annex. That's an important question that I think that the negotiators are going to have to struggle with. And this is not something that is that is abstract, and probably that it only matters to a few people that are thinking about the legal theory. This is from a paper that we're going to publish soon. This map basically shows that 75% of countries around the world have some kind of limits on cross-border data transfers, and that includes many African countries. So all of those laws in each of these African countries that are in purple in the map could be challenged under these rules. The question of whether they meet the standards of exception, that's another one, but they are potentially under danger by agreeing to these broad obligations of free flow of data. Additionally, the African Union, as you will know better than me, has developed several policy documents that stress the importance of seizing the value of data for the development of the digital African economy, the African Union Data Policy Framework, the Digital Transformation Agenda, the Agenda 2063. All of these policy documents speak about the importance of data. And I think that an important discussion to have is whether the rules that have been agreed in this protocol actually contribute to African countries seizing the value of that data, considering what I said, that it will basically allow a lot of companies to set shop in an African country and send data to other places. Finally, the source code secrecy rule. Here we see that the rule copies a lot of elements of the USMCA model, but not all of them. Something that is very useful and actually is an improvement over USMCA is that the African negotiators didn't go for including algorithms as a self-standing category in this rule. So those kind of issues that Lori was describing, if you have a law that will require that certain AI companies share a description of their algorithms, and what we're struggling with in the US is that, oh, maybe that is forbidden under the USMCA or not. That potentially is not so problematic in this context, but still the idea that you're giving these TRIPS plus secrecy guarantees for software developers is in itself problematic. And again, since we're giving these kind of rights to persons of another state party, which would include a subsidiary of multinational corporation that is probably located abroad, that is established in Africa, then that could give a lot of rights to potentially the players that, in a way, the African Union might not want to lift up. Again, this rule also has a very interesting provision in which you see in the paragraph 2 that has an exception for legitimate public interest reasons, and there's an annex that it's going to be developed by the state party. So that annex could reduce the scope of the obligation. When having those discussions, it's going to be interesting to see how the negotiators deal with policies like this one. In Nigeria in 2019, well, this has been discussed for a while now, but the latest version was issued in 2019 of these guidelines for content development in information and communication technology. Well, these guidelines have certain obligations that might very well conflict with this source code secrecy rule. For instance, it says that the government shall obtain evidence of the origin and workings of all software being used, including adequate assurance of full security of source code. It also requires multinational companies to provide verifiable information and sign affidavits about the origin, safety, and workings of software being sold and deployed within the country. So that the question is there, could this policy be challenged under the AfCFTA digital trade protocol if these software companies are established in Kenya or South Africa and seized and want to use this rule to challenge Nigeria's policy. I think that that could be dealt with through the annex, but it's very important to keep in mind all of these questions and potentially the lessons that we learned in the hard way in the US context when dealing with these thorny issues in Africa. So I'm going to leave it there so that we have some room for discussions.
Thank you, Daniel and Laurie, for that insightful contribution during this lecture series, for giving us the overview of the digital trade rules and the centrality of the USMCA and its implications, or rather the provisions of and its provisions and how they implicate the AfCFTA Digital Trade Protocol. It's interesting to note how much the big tech companies borrowed a page from Big Pharma's playbook and the listed problematic provisions of the USMCA, including issues to do with online privacy, AI regulation, competition policy, and just how much the AfCFTA Digital Trade Protocol has borrowed a number of provisions from the USMCA. We will proceed to the Q&A section, and before I hand it over to Joanna, just to begin the discussion on questions, I would like to ask either Daniel or Laurie, the USTR National Trade Estimate Report on Foreign Trade Barriers scaled back inclusion of digital trade barriers in comparison from last year's report. And the European Union's Digital Markets Act, for instance, was removed from the National Trade Estimate Report this year. And the USTR made a statement saying that the report is taking steps to return to its stated statutory purpose. So while this shift is consistent with the USA's change in stance at the JSI negotiations, do you think this position will be maintained in bilateral trade agreements? And is it probable that the USA will avoid discussing restrictive digital trade provisions with Global South countries in bilateral trade agreements?
It is a dangerous thing to predict what the US government will do in any particular negotiation. So let me start from saying, basically from Megan's mouth to God's ears, that the US sticks with this approach. And I feel quite confident that the current trade representative, Ambassador Kathure Tai, is likely to be consistent. But as with every government, we have an election coming up. And with every government, even if you don't have elections, you have people who are the trade representative changing. So in the immediate term, I feel quite confident. My understanding, but I would be very keen to hear from others on the call if this is not true, but my understanding from having asked is that right now the digital trade issue is not being discussed in the Kenya agreement, that some of the old e-commerce rules about what's a legitimate digital signature, you know, some of the things that are much more about trade facilitation and digitalization, customs stuff online, et cetera, is on the table, but that these deregulatory rules aren't, in the same way that the current US trade representative suspended negotiations on those old rules in the Indo-Pacific Economic Framework, a regional negotiation where the career staff, just the folks who are the government service agency people as compared to the political people, had continued with the old language, and she stepped in and said, no, that doesn't represent what we're doing anymore. So that is very hopeful. The other thing I would offer is that if you hear of United States officials, people at our embassies, people particularly with our Commerce Department, which has not been as consistent as our Trade Department in meeting these consistent administration policies. If you hear they are trying to push these rules in your country, may I please ask you to drop Danielle or me an email to let us know, because we can try and stop it. There is a long muscle memory of this bad position, and commercial officials and embassies who seemingly have not gotten the updated memo. So if we can help, please let us know. But for the short term, I'm fairly optimistic, actually. Of course, there is an internal fight going on, even right now. The big tech lobbyists are like a zombie horde. They are all over Washington, basically trying to kill anyone who's doing the right thing. And so far, the good guys are winning. So I want to have all those caveats so that you don't hold me responsible. But certainly right now, yes. And if you hear otherwise, let us know and we'll try and help you fix it.
Sure. I'm just
Megan, if I may, because it is true that the USTR has made huge strides in changing the position about digital trades and labeling other countries' digital policies as barrier to trade. But the NT does mention Kenya's data privacy law as a data barrier, as a barrier to digital trade, and it says that it has unclear provisions on cross-border data transfers. So that's something that tells us about, like, a little bit like the muscle memory that Lori was mentioning, and how this is not something that we should just think like this is a done deal. This could change very quickly, and the whole of Africa should pay attention to what is being negotiated between the US and Kenya through the RSTIP.
Yeah, I want to also just underscore, and we have on our website, again, rethinktrade.org, the NTE, the corporate lobbyists have gone nuts screaming, oh my gosh, they're not attacking trade barriers anymore. That NTE is full of things that we don't think are trade barriers. And part of it is because they've been in there year after year after year after year. And they like, some of it just literally, Daniel found a thing that literally is outdated. It's calling something that is now an adopted law a bill, except it was adopted a year ago. So some of it is literally, it's a 400 or 350 page document and they've missed updating parts of it. But other parts of it are this way of thinking. And so there are all kinds of crazy, not just in digital, even though this trade representative wants to be taking a different approach, there are hundreds of long-term government employees who still are thinking, looking down that same road they've been on. And there are many documents floating around that have contradictory, and that's even before you get to people, for instance, at our Department of Commerce or our Department of State, who have their own views about this that may not be as progressive. So it's yes, I want to underscore what an ongoing fight it is. Daniel is exactly right.
Thank you for your answers. Over to you, Joanna.
Thank you. So now we'll be taking questions. The first hand I saw was Tola O. So you can unmute and ask your question, followed by Janet Masharia. Although quickly, Lori and Daniel, would you prefer to have questions lumped together, or will you take them one by one?
We can take the first two and then see if they're
okay. Perfect. So Tola, you can go first, and then Janet can go next.
Yeah, thank you so much. That was very good listening. There are a bunch of things that I wanted to call out, and I just wanted clarifications and maybe just understanding the research assumptions. And thanks again, Laurie and Dana for this. I think the first big question for me is, there's a huge assumption of WTO law application or interpretation into the digital trade protocol. The AfCFTA has a dispute settlement mechanism that's supposed to resolve and interpret articles in AfCFTA agreements. But it seems like in the presentations, we've assumed that because of the WTO interpretation, it automatically applies. And I'm just curious how, if that's what you expect, or if you think that there's also room for a different judicial interpretation, given that the AfCFTA has a dispute settlement mechanism. That's one. I think, and that means that some of those terms could be interpreted differently. I think the second thing that I wanted to call out is on cross-border data sharing, and I'm just on a theme of it because I've also read the annex, right, a number of times, the protocol. There's it talks about an annex for the restriction on sharing of data with third parties. I think that there's also been an assumption that I've heard throughout this presentation that it automatically means that non-AfCFTA state parties get also enjoy these benefits. But the language used throughout the agreement is state parties, which basically means that this agreement does not extend beyond the AfCFTA. So it doesn't extend to sharing data or sharing whatever it is with non-AfCFTA state parties. So it doesn't interpret that if you have a subsidiary that's not a state party, you can share. It clearly says a person of a state party, which is defined in the same digital trade protocol, right? Very clearly. The third clarification that I wanted to understand and just call out more specifically was what room, and I say this maybe more asking for advice and understanding, seeing how much you've played in this space. How would you have approached this differently within the continent? And I'll say why I say this. The intention, my understanding of the intention of African member states is to ensure that they can be trade within the continent. That means you need to drop some restrictions, whether you want it or not, right? For instance, you don't want people abusing certain rights. You want data to try to move freely. Now, of course, given the fact that people can very quickly adopt corporate personality, that becomes a lot trickier. So how do you balance the rules between saying, I do want trade to happen on the continent, meaning we need to drop barriers, but at the same time ensure that you're not in a way adversely creating non-governance, right? And I say that because when we read the entire agreement, the entire protocol, I see a lot of language around we'll make annexes for this, we'll make the restrictions on this, we'll govern this. And it also restricts it very carefully to Africa. So I'll give an example. On the data localization article, right, it says very clearly that within state parties. So that would mean that if you were going to claim this clause, you would have to at least maintain a server within Africa, within a state party. I'm struggling to see how that's inimical in actual application. Because yes, let's assume that, you decided that you would have a server just in one African country or 10 African countries. I'm struggling to see how that's inimical in a sense to the AfCFTA or to the African continent. Thank you.
So I'm going to leave Daniel to the language in the AfCFTA. The WTO question, though, is an interesting one. And frankly, the context from which we presume that is that's the practice of the United States. So there may be a different jurisprudence created through the AfCFTA, and that would be interesting. The U.S. sort of General Counsel of our Trade Representative's Office, Office of Legal Counsel, has basically sought to have a consistent interpretation. So, for instance, in the face of certain tolling WTO interpretations, they started changing the language in our free trade agreements, in the general exceptions, et cetera, thinking they had to change the rules because the interpretations of words like necessary or what the chapeau of the general exceptions means in US practice is always done consistently with the WTO. So that is, and yes, I do get the irony of the US not appointing appellate judges and putting the WTO appellate body on ice, given that they, on the one hand, are extremely faithful to that interpretation, and on the other hand, are the principal shutter down of the appellate body. But that has been the practice. So that is why we make that presumption. Now, I think there's pressure on countries to do that, basically to make consistent those rules. And I think within trade ministries, there is typically a practice, and within the trade bar, of assuming there will be consistency. I just want to flag that because I think it's my personal take on this question in other countries' contexts is simply, it is better to be safe than to be sorry. So if there's particular language that has been interpreted a certain way, then at a minimum, perhaps in one of these additional annexes, a for greater certainty footnote is needed to make clear that this does not mean the following, or that this exception does mean the following. And so, you know, to the extent that at some point the United States may be developing new language on any of these rules, given the history of what these interpretations have been, I think it's very important to write very clear intentions, what the level of intent should be if you want an intent standard on discrimination, what, given past rulings, you don't want certain words to mean that you're trying to make clear is not what they're intending to do. So I would say that in the first question Tola raised. On the third one, there are other models. So one of the things that we think might be a more auspicious approach is what has in the past been described as the European Union cross-cutting or horizontal model on data flows rules in digital trade agreements. It was something negotiated between the European Parliament and DG Trade in the late, like around 2018. And that basically starts out with a broad statement of wanting free flows, and then has rules that explicitly forbid particular kinds of data localization, and it lists things you just can't do that basically involve requiring data to be stored in X country or Y country, forbidding data from being processed in X or Y place. It lists the instruments of data localization. And then it has a big exception for privacy. Now, in this day and age, maybe there also needs to be an exception for data security. But whatever the exceptions are, both the obligation is written in a way that isn't just an across-the-board ban on any regulation of data. It's forbidding certain practices as between state parties. And the European version doesn't write in a private interest. So Daniel will speak to that provision, and because the language that is worrying is the USMCA language, that basically the covered activity language, which opens up more broadly that prospect of data flowing outside of the countries and a broad ban of government oversight of what companies want to do. And while Daniel is answering number two, I'm going to pull up the European language and share screen in a second.
So, and Tola, thank you for your insightful comments. On the first question, I would just add that without being an expert on the AfCFTA dispute settlement provisions, I will just say that as long as any kind of adjudicator is mandated to interpret this according to international law, then you go to the Vienna Convention of the Law of the Treaties, and the Vienna Convention of the Law of the Treaties is going to tell you that you have to take into account all the relevant context. And if you have language that is very similar to the one that is in the WTO general exceptions, then it's very easy that that's going to be taken into account, potentially not completely adopted, but I wouldn't see, for instance, how a tribunal under the AfCFTA is going to define necessary in a different way that the WTO has done. I think that will be very unlikely. About the question of like to what extent this digital protocol gives rights to multinational corporations, I think that's an excellent question. I think that is not super clear for me under the protocol, because on the one side, you see the definition of a person of a state party, and it says means a natural or juridical person of a state party conducting business in the territory of another state party which maintains substantial business operations in the territory of that state party. And to me, that will cover any kind of multinational corporation that operates in 2 African countries. It doesn't matter if it's Google, it's Facebook, it's whatever. I think that that will cover it. But at the same time, you have another annex that's supposed to be negotiated in which you're going to define what's an African company, what's an African digital product. And honestly, I don't know how those 2 rules are going to interact. So that's something that's going to be very interesting to see, because I think that's a key question on what you were aiming for, is like how do we develop a model that works. And there I'm gonna go into your last question. And I think that, for instance, it will be useful for African countries. And here I am also thinking, as a Latin American, I think this for my region, I think we should try to see what the EU has done on privacy, of having uniform regulation of privacy. And in that way, you are not generating limitation on the cross-border of data at the regional level, but still you are maintaining a high ground and a high standard of protection. And as an alternative, also, I think that there's no need for an African digital trade protocol to have source code protection that goes beyond TRIPS. I think that that will be a line that I will draw. I don't think that that's really necessary. And the third point will be, again, trying to see what happens if a country in Africa negotiates a digital trade agreement with a third party, because I don't see anything in the protocol that's limiting that. And in the moment that that happens, then it's very easily for that country to be a siphon for all of the data that's being held in Africa to other countries.
I just want to add on that point, if you look at the draft leaked language for the AfCFTA on the non-discrimination issue, it has a most favored nation clause as well as a national treatment clause. And so that same issue, once you, if one country has agreed to a crazy version of those rules with another out of Africa country, and then starts giving those rights or adjudicating that, it's the same set of issues. I'm going to just very quickly share my screen again so that, let's see if I can do this smoothly. I just am trying to do it and it's not picking it up. There we go. Here is the European language. So the first provision is committing to free flows, cross-border data flows, and then to that end, a party shall not restrict cross-border data flows taking place between the parties. So it's very clear. It's not with respect to the business of a covered entity, between the parties, in the context of an activity that is in with the scope of this chapter and the definition that is below. And then requiring the use of computing facilities in that territory, requiring localization of the data, prohibiting storage or processing someplace else, etc. It lists the things you cannot do. And then it references the general exceptions, but as we've noted, not of a lot of use. But more importantly, in a separate article, it has each party may adopt or maintain measures it deems appropriate, so that the measure is self-judging, to ensure the protection of personal data and privacy, including through the adoption and application of rules for the cross-border transfer of personal data. Now, the reason why this is necessary is if you're going to enforce even things like correction, minimization, you can't have the trapdoor that as soon as it goes out of your country, or if, you know, in Daniel's vision, out of the region, you escape the privacy rules. It's the problems that the European Union has had with any number of different regimes right now, adequacy of what happens when it leaves the European Union. So for any country or region, this privacy rules, you have to figure out, again, the panel can say that's not really privacy. They could challenge that, but what the measure is, and if that measure is appropriate, that is self-judging. And then if you see the scope, it applies to measures of the party affecting trade enabled by electronic means. Now that is broad. I'm not saying that's an ideal definition, but that does not include the private actors' interests in moving data wherever the heck they want. And we think that is a major flaw in the US model. It's basically making the government's obligation contingent on what the companies decide is in their interest, as compared to prioritizing the public interest and setting up rules between state actors. So we think this approach is a more auspicious way of thinking about it, so that you don't have TOLA, the notion of, you know, just arbitrary blocks of data. At the same time, you preserve the policy space, ideally after getting a regional law in place. And if you contrast that with the no party shall prohibit or restrict, this is the US law, if this activity is for the conduct of the business of a covered person, data going anywhere, as long as you are an investor, you don't even have to be actually incorporated. I mean, it's that a covered person can be a cross-border service provider. So I will just leave it there as a thing to throw out for discussion and consideration.
Thank you so much for that, Laurie. Tola, I hope your curiosity has been satisfied, and I can see there's a lot of discussion going on in the chat, so I think we can leave that there. Janet, you're up next. And if there's anybody else who would like to ask a question after Janet, please feel free to raise your hand. I see Kathure and Nchiko. Okay, so we'll have those two after Janet. Janet, go ahead.
Hi, great, thanks. And thank you for the wonderful presentation. I had quite a number of questions, but I'm just going to limit it to two. My first question, and this again is back to the Digital Trade Protocol, the text. Article 34 talks about emerging advanced technologies, and of course, there's an annex to be negotiated by members. I'm just curious, maybe if you were to summarize like 1 or 2 points that you feel should be in this annex or as an outcome of these negotiations. I would like to get some insights on that. I also am curious about the negotiations of this annex, and not just Article 34, the many that we have mentioned in the Digital Trade Protocol, and the extent to which you think they should align with their ongoing work on e-commerce at the WTO level. I'm just thinking about it from that perspective, and I would like to get your insights. Yeah, I'll leave it at that, and you can just post the others in the chat. Thanks a lot.
Should we take another question, or would you like us to respond to that question from Janet?
We can take one more from Jacob.
Oh, yeah, thank you. Thank you very much. Mine is really a basic one and really interesting conversations. But what seems to be missing for me is the place of the non-lawyers, the ordinary citizens. So like, what would be like I know this is kind of a broad question, but what would be really like your message, like for them or like to them? Because the conversations are really at a more high level. It sounds a bit like really technical. So to the non-lawyers, what would be like really like your message? I know there might be many, but maybe just a couple of them, and either Daniel or Laurie can take this.
While Daniel is looking at the language, I suspect, to answer that question, because he is our in-house expert, to the extent we have any expertise on the text of the AfCFTA as compared to the mess in the US, I will take a stab at Jaco's question. And the gist of what we have found is it really depends on what country and what audience to communicate. But in the US, what we know is one of the few issues in our very polarized political situation that people agree, the most conservative Republicans to the most progressive Democrats, is that the big tech companies have too much power in our lives. And people understand it different ways, depending on where they're situated on the ideological spectrum. But so when we're trying to communicate broadly about the issue and not in a technical way, because we're having a discussion here amongst lawyers, and we're talking about a critique legally and what alternative policies could be. But obviously, when we need to communicate the implications for our day-to-day lives of our residents in our different countries, again, it's going to be very different. But in the US, because of that reality, where we typically start with the story is who's trying to do what, because all the technical legal terms aren't that interesting. So the story is basically right now, finally, Democrats and Republicans are agreeing on a few things. And that is, we need to make sure our kids are safer online. and there's more privacy protection. And that the big companies have too much power and they shouldn't have been allowed to get that dominant and that big. And Democrats and Republicans in Congress are working to try and fix that, but the big tech giants don't want to be regulated. And we basically tell a story of they have learned they may not win this debate in public because the American public is united that they want this fixed. Therefore, they're looking for quiet, secretive places to try and get the same agenda taken care of. And that's when I talked about handcuffs. They're trying to handcuff Congress and they're trying to handcuff regulators using trade rules. And then sometimes we tell the story about what happened with patent extensions. I mean, the United States didn't have a 20-year patent. That was because of the WTO. We had a 17-year patent. We also had longer monopolies imposed on us after our Congress had rejected Big Pharma trying to do that in the sunshine of regular congressional procedure for 20 years. They had been stopped and they slipped in and made the US change the law through the WTO. So we tell that high level story, and then what does it mean? So depending on where you are in the country, if, you know, when we're talking to people who are in the agriculture sector in the rural parts of the country, we talk about right to repair. They're fighting for the right to be able to get their tractor on their farm fixed. And the companies that are making the tractors want to make sure that without the software and paying a ransom, they can't get a small thing fixed, and they want the right to have independent repairs. So basically we start, it's like that third slide. We start with the thing that people care about and go backwards. On the, and the role, of course, of the individual citizen is to try and get their elected official to make sure the rules represent them. On the issue of coordinating with the WTO, I think it's worth just considering the legitimacy of that whole WTO negotiation, given it was never agreed under the regular rules of how you can launch a WTO agreement. So what is that agreement? If it were to be an actual plurilateral of the WTO and adopted, then it also needs consensus support. I want to just reflect what happened with respect to the joint statement initiative on investment at the most recent WTO ministerial in Abu Dhabi, where there was a push to get that adopted as if it had been a legitimate WTO officially ministerial conference launch negotiation, and a variety of countries said no. And that is not a legitimate. So there's a whole question about, as a general matter, of course, we're fighting because the US is in that negotiation at the JSI, and I don't think we have the ability to get them out of it. So we're fighting to try and, you know, support those who want to make all the US approach consistent with their domestic laws and to make that consistent wherever the negotiation is. But for countries that may not be in that JSI, the staying out may not be a bad idea, and or for countries that are in, that have policy space to protect, that there is a possibility of questioning what exactly legitimacy of that process is. It's probably worth thinking about. And Danielle, I'll hand it over to you.
I'm just gonna answer the first question that Janet made, and I appreciate a lot that question because it allows me to say that it's not like we believe that there's something inherently wrong with negotiating a digital protocol in the context of the AfCFTA. Not at all. That particular provision that you're mentioning, emerging and advanced technologies, I think that's super interesting. That's not something we have seen in the US model. So I'm not gonna offer like something very insightful about that because it's not something we have been studying that much. But I think that, for instance, it gives the room for AfCFTA countries to figure out what's their position about AI regulation. We're seeing a lot of discussions about that. Many discussions are being handled by groupings of rich countries. You have the OECD discussing this, you have the G20, and developing countries have been largely excluded. So I think that this is a room in which developing countries, a group of developing countries, could say, what's our take on this existential question of our time? So yeah, not exactly, I don't know what should go into that annex, but I think that people should put a lot of thought on what to put in there.
Thanks for that, Daniel. Due to time constraints, I think the last two sets of questions we'll take for today are from Kathure and from Michelle. So Kathure, you can go first, and then Michelle, you can ask your question, and the two panelists will take those together, and then we can close off. Unless there's anything super burning, which I think we'll probably try and make time for.
Thank you so much. I'll turn on my video just to say hello. It's great to see you all. It's always good to see you, Lori and Danielle, who was my student years ago. And I have to say, I found this absolutely fascinating. I think this is really, really important research. And Danielle, I'd like to follow up with you on some work I've been doing with the United Nations, comparing provisions across trade agreements, because I think it might be helpful to use some of what you talked about today to kind of flag for negotiators the implications of certain provisions over others. But I'll follow up on that separately and can make some of that work available to all of you too. We did these handbooks for the UN for trade negotiators on dealing with crisis and then sustainable development. And this was all before the AfCFTA digital protocol, even though we use so many examples from other AfCFTA instruments, because I do feel that they're very innovative in ways that the discussion has brought up. But my comment and my question is about something a little bit different. And again, I feel like these have been some very, very important examples of things to look out for, to be cautious about, and to think about. And I think Danielle is right, as these annexes get developed, all of this detail that is being discussed today might be something that gets incorporated into the annexes. But I guess part of my question, so I teach full-time at Georgetown Law School, and I co-direct a center there on inclusive trade and development. And one of the things that I'm pushing to do with my work is to go closer and closer to what this question that was just asked about ordinary citizens. How do you take this all down as close to the individual as possible? How do we really think about how all of these rules are impacting real people? And I guess that leads me to think that there might be a little bit of nuance on some of this. And I'm just curious to hear what you both think. So let me just explain with a couple of examples. One is, I always thought, actually, Lori, that Europe had better laws too, and that I would much rather be covered by Europe's privacy laws, until I wound up living in California part-time, even though I teach in DC. And California has privacy laws that are very similar to Europe. It's all in the details, because these privacy laws, and I think Europe works this way too, as an individual, you have to constantly opt in for your protection. It's not automatic. Every single time I go online, I have to check a box. Every box is different. Every question is worded differently. Everywhere I go to protect myself is different. And I can see that my data is getting out there, despite my, I hope, quite consistent implementation of these rules on my own behalf. And I guess part of what I worry about a little bit is that if we don't think more about how individuals are impacted by these things, and I'm a lawyer, right? So for me, this is frustrating and slightly terrifying. But what about just for a person who doesn't have a legal background and is trying to protect their rights in this area? So we're so focused on what governments are doing, but I think that we need to be thinking about how all of that actually reaches the individual. And I guess I raise this data privacy point, one, because I think we should be careful of kind of looking at Europe as the model. I think there are aspects of what Europe is doing that are a good model, but there are aspects that are not. And I think part of what I'm concerned about is that I see Europe's model being exported around the world. And then it makes it harder for countries like Kenya or Ghana or Benin to come up with their own way of regulating data, because they have to be able to show that they are adequate in those protections to be able to trade with Europe, for example. So I think there's this other layer of this. And could you think about whether or not some kind of multilateral rules? I mean, I think you can take out things like you're talking about, right? I mean, there are clearly some things that we need to be concerned about, but could multilateral rules in some way protect smaller countries to have the policy space to be able to make those decisions on their own without necessarily just having to follow the model of the most economic powerful, which in this case is Europe, because they have the most detailed laws. So I just would love to hear what you think about this. I'm working on something right now on inclusive data regulation. I will take a lot of your research into account because I think it's really, really good research. And I just wonder, could you take us down to that individual level just a little bit and say whether or not you think that there might be any instances in which you would want to agree multilaterally on some of this to give countries policy space? So can you use a multilateral instrument to provide policy space rather than just restrict it? And by the way, also the Article 30 of the Protocol on Dispute Settlement, I think, deals with this question of the Vienna Convention that Danielle mentioned earlier. So just to refer others to that, going back to the previous conversation. Thank you for this.
I can talk about the data privacy thing.
Should we get the question from Michelle?
I didn't see another hand.
Thanks, Laurie. Thanks, Joe. Thanks, Daniel. First is to reiterate Kathrine's comment. I think it was a wonderful and very incisive presentation. I just have two very straightforward questions. One is borrowing from what Kathrine has said. I'm very interested at least in comparing the definitions attached to e-commerce or digital trade in the USMCA, in the WTO e-commerce program, and in the AfCFTA digital trade protocol, and whether in your view this has any impact in terms of the scope of application and how broad or narrow it needs to be, and whether you see any precise definition being attached to e-commerce at the WTO in regard to the JSI, because we already know that WTO has defined e-commerce under the WAC program, but I'm uncertain if there's a precise definition that has been given to the JSI, or the work being done under the JSI. Then the second question is in terms of practical steps forward. So we do appreciate that indeed some of these provisions really have a huge negative impact on African state parties and their people. But in terms of the practical steps forward, and also in terms of how we got here, appreciating that I think there was a lot of influence, not necessarily from governments only, but also from big tech companies in terms of the lead up to the negotiation. And I think African state parties are caught between a rock and a hard place. This being that they want to attract investments in their home countries. They want to attract foreign direct investment from these big tech companies. At the same time, they really want to regulate their policy space. So how can this be balanced? And what really would you say was, quote unquote, the light bulb moment for the US to abandon some of these positions that it had at the WTO, and what really can be used as a persuasive tool for African governments seeking to safeguard their policy space, while at the same time legitimately attract foreign direct investment? Once again, thank you very much for the presentation.
Thank you for those questions. In a way, for both of those questions, the place I would start is just, and also to even harken back to the question about the annexes and the ongoing negotiations. My take of this particular discussion is that with respect to the international rules, as a general matter, preserving the policy space for the regions or the countries to sort out these questions of what is the way best in that region or country's context to deal with a variety of these issues on privacy, et cetera, is the highest and best approach because, and not to sound cynical, but over 30 years of trying to fight for good rules in trade agreements, the power dynamic, in my experience, the farther away you get from the governed in the institution of where the governance is being decided. So when you get something as attenuated as, say, a WTO negotiation, it becomes extremely difficult to overcome the concentrated power of big commercial interests, and for that matter, big countries. And the notion of somehow the perhaps vastly majority, but disparate and disaggregated people power being basically aggregated to a point where the people win and you get a positive establishment of a rule. It happens. It occasionally happens. It happened in the US-Mexico-Canada agreement where the Democrats in Congress were going to blow up Trump's whole agreement if he didn't put in enforceable labor standards. But it's unusual. And I think the thing that actually has made me very negative about the prospect, and this gets to Katrine's question about, you know, are there ways to put good rules in a WTO digital agreement that preserve countries' rights, is in the face of the deadly COVID pandemic, WTO countries could not get together in like a world deathly crisis to temporarily waive the TRIPS rules and allow access to the best vaccines, much less treatments and tests, which was a temporary short-term waiver of rules in the face of a humanitarian crisis. And yet the way the construct of that institution is set up, the dynamics of the greed of individual countries being persuaded by, in this case, it was pharmaceutical firms, I do not have a lot of optimism as compared to the people power of being able in your country, where you have accountability over your government, where you can become ungovernable if it comes down to that, throw them out in an election, protest in the streets. So I'm not extremely optimistic, Katrine, that there's a prospect for having good rules in these agreements. And the way we have approached them, certainly under the current dynamic and structures, is to try and maximize policy space and not be able to have the special interests that have a lot of leverage, because indeed they are offering investment, they are offering jobs. Where's that data center going to be created in Africa for processing of data? There is a lot of leverage there to that the disparate individuals who want privacy rights, who want a fair shake with their new app on an app store, that power dynamic does not favor having these international institutions generally have the positive policy space protections against the big. So when it coincides with the big wanting some of the things we might want, then it might work. The Michelle, on the definition of e-commerce, that's an interesting question. And you know, there's been a huge contest about what is e-commerce and what are digital products. Is the product, is the service, and it remains unresolved. And I think in parts, the naming of that JSI e-commerce is a little bit an artifact of the sort of history of that being the name and the new brand not coming out. And as far as the balance between big tech's influence and throwing around investment in countries wanting to attract that investment, the light bulb moment, honestly, in the US, in part, was number one, seeing the provisions being proposed that were in an agreement. So we weren't making up what could happen. Here was the language. Here were the specific US proposals. And in that report we put in the slide, we listed the co-sponsors so that everyone was basically called out. You signed up for this legislation. The footnotes on some of those have like 200 congressional co-sponsors to make sure, like, yo, your name is on this thing, and these rules are going to this thing. And we had to make it that specific so they felt ownership. But also another thing was the research that actually had the corporate lobbyists on the record writing to the USTR saying, this law in this country, illegal trade barrier, this law, illegal trade barrier, and then showing the US trying to adopt the exact same laws. So in a way, it was the companies fessing up what they intended to do with these rules once they got them in place that made clear this was not public interest lawyers trying to scare people. This was the companies out front saying what they were going to do. So those are a few insights, and passing the baton to Daniel.
Thanks. So I want to address for the second part of the question that Kathryn made, and also discuss a little bit like all of these different privacy models. It's absolutely true that for some, GDPR is kind of outdated right now, and the whole idea of opt-out models is being changed by data minimization, for instance. That was the key principle of the American Data Privacy and Protection Act that was being discussed in the US Congress last year. but could get passed, but it's also being taken up by state level policies in the US, like in Maryland and in Maine. So this is definitely a moving field. And that's why we think that it's very concerning to establish binding constraints in trade agreements to say we are gonna agree that we're gonna do things in a certain way. I'm just gonna go a little bit further into that because it goes into the question of the exceptions. So if you have exceptions that, if you have a rule that doesn't allow you to regulate data transfers, and then you have exception that says any kind of regulation, you could pass it, but it has to be necessary, then the tribunal gets into place in which they are going to be able to choose which is the model that is right for your country and is not the one that is being domestically adopted in democratic processes. And that's one of the things that we consider is so problematic, that these discussions are being seen through the trade lens and not other lenses, particularly when we're talking about privacy, which is human rights. So definitely there should be room for multilateral discussions on these kind of issues, but maybe not through trade. Maybe there has to be more discussion about data privacy in other realms in which we're taking the human rights question first, and then the facilitation in as a secondary consideration. And regarding the excellent question that Michelle made about like, okay, yeah, but we really need investment. Like, this is important. We need to bridge the digital divide. Those are all pressing questions for people in the developing world. But that brings me back to the idea of investment state dispute settlement and how that was being sold to countries like the answer to attract investment. So you're not going to regulate, we're going to impose all of these binding constraints on your ability to regulate, and then you're going to get swaths of investment. It's going to be a lot. And then 30 or 40 years after these agreements started to pop out, there's economic evidence that shows that foreign direct investment did not increase based on these agreements, on these protections for foreign investors. And I see that this will play out in a very similar way when we're talking about digital trade. So I believe that in order to attract investment, we should think about other stuff like upgrading skills, digital public infrastructure, actual infrastructure in our countries. Those are likely much more important for foreign investors to actually go into a country and say, okay, I can do business there, than a country resigning to its ability to regulate. There are important questions there about like how within Africa you could have certain rules of the road that allow for a unified digital market that I think that are completely legitimate. The question again is how we don't allow free riders to come into the continent, use those rules, and then not generating progress in the objectives that we actually want to meet.
Thank you so much for those responses. And also thank you to Daniel for sharing a bunch of resources in the chat. So if anybody would like to look further into these references, there's a lot of information in the chat as well. And Daniel has also been so kind as to share his and Laurie's email address in the chat. So if you do have any follow-up questions, you know where to direct them. I'll now invite Laurie and Daniel to give us any closing remarks that they have, and then Megan will give us our vote of thanks, and that will be it for today. Thank you so much, everyone.
I think my only closing remarks is just again to appreciate this opportunity and to look forward to continuing the conversation. It is an area where we have gained quite a bit of knowledge over the last 3 years in the US context, and we are very aware that the US corporations are now in a rage about not being able to call the shots on what the US government position is. And we are very keen to partner with people in other parts of the world where the US corporations might now be shifting their priorities as a way to try and still impose the rules that they think constrain governments from overseeing them. And in a way, I feel as someone who's working in the US that, you know, we're very much behind the rest of the world in regulating these companies, that many of the biggest ones which are based here. And we have a lot to learn from how other countries have done these policies. I mean, vis-a-vis Katrine's point about the GDPR, for sure there are limits, but it was a joy to be in Europe recently, and every time I got in a website to be asked, do you want to allow cookies to invade you from this website, and being able with one click say, no, I do not. And shutting it down. Yes, it can be a pain to have to do it each time you start a new website, but now my computer knows when I'm in Europe, Google can't put cookies on my computer. So are there lessons to be learned amongst all of us? Yes. But I think our big takeaway was, and again, the US is so far behind the rest of the world, that preserving the policy space, and as Daniel said, not locking in rules that constrain the ability to be able to develop what the best models are. And this is an area that's constantly changing. I mean, when we started out, we were not focused on AI. We were focused on privacy, competition policy, but AI has elevated, and we started thinking, wait a minute, we thought that source code provision was a problem for X and Y. It turns out maybe the biggest threat is in the AI context, something no one is even discussing with, you know, detail amongst policymakers until relatively recently. So just with that as the background, I hope we can work together. It is obviously going to be a mission of trying to figure out how to get these rules right, and to make sure we're protecting the public interest and not inadvertently, because I think a lot of, you know, members of Congress had no idea they were voting for these really crazy rules when they voted for more labor rights in the new US-Mexico-Canada agreement. And yet a lot of members of Congress ended up voting for a set of rules that now they're totally opposed to. So I will end there. And Daniel.
I'm just going to say that I love the conversation, and thank you for the invite.
Okay, thank you so much, Laurie and Daniel, for your contributions to this lecture today, and as well as the audience, both the general public and the academic forum representatives. We thank you for spending almost 2 hours of your Saturday evening with us. Thank you so much. I would also like to thank you, the founding editors for the Afronomicslaw, Professor Kathure, if he's still around, and Professor Hayo, also for making the connection between the forum and Laurie and Daniel. Is Kathure still in the room? Maybe you can say a word, and that will be it from us. Thank you all.
Well, thank you so much, Laurie and Daniel. That was really superb. I was in a class taking notes. This went very well. Also to the audience for being here on a Saturday and streaming. I know it's very expensive to stream, especially from Africa. And also to our two superb moderators, Megan and Joanna. I'm super proud of you guys and all the members of the academic forums. This has been super great. Thank you so much, everyone, and have a good rest of the weekend. And I hope, as Laurie and Daniel have said, this conversation will continue.